All right, this is chapters 3 and 4 overview for the business law homework. Chapter 3 was a massive chapter. It started off talking about jurisdiction, which is the power of the court to hear a case and render a binding decision. And it moved into original appellate personam jurisdiction and like stuff like plaintiffs, defendants, summons. I didn't know what a summons was. It's kind of self-explanatory, but I had to really look into that. It really just gives you all the terms and conditions of what the federal court is and what they do and who has to be there, what you're called, all of it. It tells you about the structure of the court system, the federal court, the intermediate courts of appeal, and the court of last resort, which is the Supreme Court, which is why on the news they always talk about someone got sued, or it might go to the Supreme Court for a final decision, something like that. Talks about state court systems, which is almost the exact same thing as the federal court systems, such as the state trial courts, the intermediate courts of appeal, the last resort for those state courts, which all the state courts actually, a lot of them call their state courts a Supreme Court, which kind of doesn't make any sense to me because there's actually a Supreme Court. Unless it actually is a Supreme Court, it doesn't really make that much sense to me while reading it in the book. Chapter 3 keeps on going to talk about the jury, what the jury actually does, how they become a full jury, what all goes into picking out the jury. And then it goes into kind of how the trial goes, where you start off by picking a jury, the jury selection, and then the opening statements, the plaintiff's case, the defendant's case, the conference on jury instructions, the closing arguments, and the post-trial motions. What I thought was kind of interesting is the voir dire. I'm so sorry if I butchered that. I don't know how to say that. Which is the process whereby the judge and or the attorneys question potential jurors to determine whether they will be able to render an unbiased opinion in the case. I didn't know they did that, which is very interesting. And I didn't know what the appellate procedure was, which is they affirm, modify, reverse, and remand, which is very complex, in my opinion. And then moving on to chapter 4, which is lengthy, almost just as lengthy as chapter 3, but a little less information given to you. It starts off by talking about alternative dispute resolutions, or ADR, which is resolving legal disputes through methods other than litigation, such as negotiation and settlement, arbitration, mediation, private trials, mini trials, summary jury trials, and early neutral case evaluation. And the book continues on to go through each of those terms individually. The summary of a jury trial is an alternative dispute resolution method that consists of an abbreviated trial, a non-binding jury verdict, and a settlement conference. And I don't fully understand the ADR. Honestly, there's a lot of stuff that goes into it. Like the mediation, you can get a mediator from the Yellow Pages, a Better Business Bureau, Federal Mediation Conciliation Service, the FMCS, JAMS Resolution, Mediator.com. The state may also have organizations for mediators. Like, there's a lot of stuff that goes into business law, which is exciting for bringing up this entire semester.